Number 26, Ortiz versus Ciox Health. Judge DiFiore is recused at her request, and with the agreement of Judge Rivera, I'll supervise arguments. Ms. Nam, I believe you're first.
Thank you, Your Honor. May it please the court, my name is Sue Nam from the law firm of Reese LLP. We represent the appellant plaintiff Ortiz in this case. I ask to reserve 2 minutes
You
of
have
my
that.
time for rebuttal. Thank you. This court, in its prior decisions, has expressed reluctance to recognize a new private right of action. But this case is unusual and distinguishable from this court's other decisions in that confirmation that a private right of action is here will not create a new cause of action, but will instead preserve a check on compliance that has been placed for decades. The district court in this matter was the first court, either federal or state.
Counsel, I'm on the screen. Hi.
Yes.
Yes, thank you. So why doesn't the existing enforcement structure make whole someone like Ortiz?
Well, our position is that the existing structure has always recognized the private right of action. The enumerated.
Yes, but under the existing structure, it allows for an Article 78. It begs the question whether or not that's a private right of action. But I understand the point is a plenary right of action and that you can have an opportunity for a class action. But why isn't the Article 78 and perhaps some other enforcement mechanism enough to ensure that someone like Ortiz, who's now deceased, now we're talking about the estate, could be made whole, and that we can ensure that there is some other mechanism to deter the conduct in the future? Why isn't the existing structure good enough?
Well, first of all, the CPLR 7806 makes explicit that Ortiz does not have a private right of action for damages. That statute states explicitly that you can only bring an Article 78 action if you have a right to bring an action for damages in the Supreme Court, a plenary action. The position that the defendants have taken in this case is that Ortiz does not have a private right of action in the Supreme Court at all. So there is no remedy for this situation. There is no remedy for a refund of overpaid charges. If there is no private right of action here, tens of thousands of people, just like...
Why can't you? I'm a little confused. Why aren't they correct? I believe they argue that you can get the refund because I think it's Section 13. There's another section of the public health law that requires compliance with the duties and obligations under the public health law, and that could be part of an Article 78 demand.
Well,
why can't you get the refund?
because Article 78 says you cannot get a refund unless you can bring a claim for damages in Supreme Court. And if there is no private right of action, you cannot bring an Article 78 proceeding for incidental damages. That is just the way that the CPLR is written.
But if the public health law says that you can proceed to protect your rights and proceed under the other sections, 12 and 13, whatever the other sections are, via an Article 78, is it not possible to harmonize the two by saying what the public health law does is allow you to enforce all the duties and obligations that the provider is subject to under the public health law? It's just you're limited to doing that in an Article 78 proceeding, so that it would trump what I think you're saying are obstacles in the CPLR.
Well, first of all, the Public Health Law 13 does not say you have to proceed under the 78. It says you may. And unfortunately, Article 78 doesn't allow you to ever recover damages because the defendants are saying we can't bring a Supreme Court action for damages. So we're out of luck. So the tens of thousands of people who have overpaid are at the whim of providers to see if they could ever get a refund. That cannot be what the legislature intended when they stated that.
What about reaching out to the Attorney General or the Commissioner? Is there any way that any mode of enforcement under the public health law that they're authorized to take on might indeed provide some relief?
Your Honor, PHL 13 does not provide for the fines to go back to the people who are overcharged. There is no mechanism. So in effect, if we read Public Health Section 18.2E as having no private right of action, even though it says the reasonable charge for paper copies shall not exceed 75 cents per page, those people who were charged in excess of 75 cents per page have no recourse. Tens of thousands of the very citizens that the legislature sought to protect.
So
Did
why,
you s-
I'm sorry, Judge.
No, that was me, but you can go ahead.
Sorry. Sorry. So why should we read a private right of action when the legislature has expressly prescribed such a remedy elsewhere in the public health law?
But, Your Honor, the legislature did not limit the remedies. It says may, and also says specifically that shall not abridge or alter rights of actions or remedies now or hereafter existing. So,
But the
this-
legislature around the same time contemplated refunds in Medicaid. So in Section 19, where they explicitly provided for a refund there, leading us to believe that here they considered it and rejected it.
Well, Your Honor, there's nothing in the record, in the legislative history, or in the statute itself that says that they considered and rejected such a remedy. It just isn't there. And this statute was expressly provided to protect citizens of the state.
Well, one really good indicator of that would be the statute itself. I mean, the legislature certainly knows how to create private rights of action. They've done it before. I was just looking at General Business Law 349 the other day. There's a private right of action in there for deceptive trade practices. You know, the best indication of their intent would have been to say, there's a private right of action. And it seems as if, or at least one could argue, that they came to the conclusion that that just wasn't appropriate in this context.
Your Honor, the whole notion of an implied private right of action is a legal construct. It's a legal construct to provide for those instances where the statute doesn't expressly provide for a private right of action. But the circumstances, the policies, the case law that's already been decided in this state all suggest that there is something that was overlooked.
Well,
the
that would lead you to
intent-
Sheehy, right?
Yes.
The test for that exists in our court.
Absolutely.
And do you believe that this private right of action fits appropriately within the overall legislative scheme?
Absolutely, Your Honor, because each of the statute, or the elements that must be considered are met here. Clearly, our plaintiff appellant meets the requirement that she was the one that legislatures wanted to protect here. Secondly, the indication is that this provision, having a private right of action, would fit seamlessly into the current enforcement scheme, which for decades have included implicitly and explicitly a private right of action.
I'm a little concerned that the legislature might have done some sort of, evaluation that including this private right of action would lead to a huge explosion in costs for the healthcare providers, which ultimately would get passed on to the medical consumer. And this was kind of an expense-saving device on their part.
There's nothing in the legislative history about this particular provision with the 75-cent cap that indicates that this was in any way for the benefit of medical providers. Clearly was meant to protect consumers from overcharging in a very clear and simple way, 75 cents cap. Now, respondent Ciox has violated that in tens of thousands of instances. And it could not have been the intent of the legislature to leave those people who are overcharged without restitution, without remedy.
I'd like to go back to the third factor of She. Can you talk about that, please? Because we've established that that is the most important one, and how do you reconcile that with your position?
Well, Your Honor, I think that absolutely it reconciles with our position because it works seamlessly and has for the several decades after this provision was enacted to have a private right of action. This notion that the defendants would be open to a flood of litigation is just not true. Since it's been enacted, there have been private right of actions, and there's been a handful of cases, and they have defended them vigorously and well. But to say that there is a sea change now, if this court to find that there is no private right of action, could open some serious consequences and implications for the consumer. Right now, the
Can we just stay? I agree with you that there will be consumer consequences, but I think the judge is focused in on what may be the linchpin of any analysis that ultimately comes out of the court by identifying the third she-he factor as the one we should be looking at. There seems to be a number of cases that the private right of action was rejected. I count, starting with Schlesinger versus Valspar in 2013, Metz 2012, Smoke Sprites 2009, McLean 2009, the Kennel Club. There's a number of them around animal cruelty and private right of action. Usually, what the court is looking for is whether or not there are more substantial enforcement mechanisms affirmatively provided for in the statute than what could be provided for by a private right of action. Would you agree with that analytically?
I believe, Your Honor, that this case stands quite apart from the other cases.
How so?
Because in the other cases, there hadn't been sort of a set regulatory scheme that included a private right of action for decades that were incorporated into the way compliance was viewed by healthcare providers. That has been the state of affairs for 30 years. And for this court to now say, after cases have been decided the other way, to now say that there is no private right of action has serious consequences and implications for the regulatory landscape, which is the very regulatory landscape that this court is quite concerned about, justifiably. We believe that...
Your argument strikes me as a little, over here, sorry.
Yes.
It's a little unusual, because you're saying, in a way, we don't really have to answer the question whether we think the legislature would have wanted to have a private right of action, because whatever the legislature might have thought, people were bringing suits for a long period of time, and that's a sufficient basis to keep doing what we're doing. That seems a different kind of test.
No, Your Honor, I don't believe that that is a different type of test, because ultimately, this court looks at whether an implied private right of action coalesces smoothly with the exact existing statutory scheme, and we have shown over decades that it in fact does. So I don't think we are applying any different test than this court has done previously. I think this situation absolutely checks every of the boxes that this court requires.
Thank you.
Counsel, I thought in part you
Yes.
were arguing, just to clarify this, I thought in part you were arguing certainly what Judge Wilson was asking you about, but also that there were private lawsuits already in existence, and so the public health law's provision that says it all existing avenues for actions continue and are not being displaced. I thought that was part of your argument, that that's another signal that this would work what you call seamlessly with the existing framework.
There are some complications as to how PHL Section 12, subsection C, 6 rather, was enacted and when it became effective. There are some complications, but it reads as it reads today. When we look at the statute that is in effect today, it absolutely says it is not meant to confine the remedies. And so I think as the statute has to be read today, it does support our side. Thank you, Your Honor.
All right, thank you. Next up is Ciox Health. Mr. Lefkowitz.
Thank you. Good afternoon, Your Honors. Jay Lefkowitz from Kirkland and Ellis for Ciox Health. And I'd like to just start to answer Judge Canataro and Judge Singus's questions about Sheehy, and then it turned to the questions Judge Rivera asked of counsel. I think Sheehy is the definitive statement of how this court approaches these issues, and what the court said there is that where the legislature has not been completely silent, but have instead made express provision for civil remedy, albeit a narrower remedy than the plaintiff might wish, the court should ordinarily not attempt to fashion a different remedy. That's the situation here. We have, first and foremost in Section 12, a robust public enforcement mechanism. Both the Commissioner and the Attorney General can bring actions, and under the state finance law, and I believe this answers part of Judge Rivera's question, at Section 411B2, it expressly permits the Attorney General or the Department of Health to pay out, quote, monies to be distributed solely or exclusively as a payment of damages or restitution to individuals or entities specifically harmed by a party's conduct.
So is that what you were referring to as a refund in your brief?
There are two different avenues actually to get the refund here, Your Honor. There is the public enforcement option, and as this court has said, both in the Metz case involving boat disasters and in the CPC McKesson case involving the Martin Act, even in the absence of any other type of private remedy, public enforcement is sufficient to hit prong 3 of Sheehy. But there's also the Article 78 that Section 12 specifically talks about, and in Article 78 cases, money damages that are incidental to the injunctive relief, to ensuring that the law is obeyed, are also available.
What would be the
But those don't-
injunctive relief? I'm sorry,
Sorry,
Judge.
those don't translate to money in the person's pocket. So the person who has put out money to get their medical records, they can't avail themselves of getting a refund because the Article 78 will just compel the hospital to make sure that they abide by the prescribed rate. And there could be a fine by the commissioner, but there's no avenue to actually put money back into those people's pocket.
So two answers, Your Honor. There is both a public answer and a private answer. The public answer is that the Attorney General, under the state finance law, can order the restitution to the individual, and under the Article 78, as this court found in the Health Plan versus Baku case, and again in Signature Health versus the state of New York, there can be an order requiring the commissioner to reimburse subscribers who were overcharged. And that's because the money damages, refund of whatever was overcharged, is considered to be incidental to the violation of the statute. So in this situation, Your Honor, looking at the third Sheehy test, which is, this court has said, is the most...
Counsel, if I may, I'm over here on the screen.
Sure.
So I just want to clarify, I think you make some very good points about this enforcement and these avenues, but it does strike me that both of them, likely it helps you very much in this case, given that this is an attempt at a class action, but it doesn't help the 1 or 2 or 3 people, because it's likely the AG may not do that and the commissioner may not pursue that, especially if the amount is quite small. And I think that's where your adversary has also made this other argument that it cannot be that if the legislature is trying to ensure access, that it would not have wanted an individual to not be able to get back money that they put out first because they need these documents, even though they're being overcharged, and then not be able to recoup that later.
So,
right? They have to be beholden to, I understand your point, I actually think it's a compelling one. They're beholden to a state actor to choose to work on their behalf, but the likelihood of them doing for 1 or 2 people is quite small.
well,
Right?
so, Your Honor, I'll give you a couple of answers to that. First of all, if in this situation, for example, Ms. Ortiz, once she alerted Ciox that there had been an overcharge because Ciox had thought she was not a protected party, turns out she was, they simply refunded the money. And oftentimes, that's what happens. She would have had the ability to simply move on her own for that Article 78. She could have told the Attorney General or the Department of Health, and in the Weg versus De Buono case, recently, in 2000, the third department upheld a 30-day medical license suspicion, 5 years of probation, thousands of dollars in penalties. So if the government decides there's something egregious, they certainly can and do take action, but there's also the private option. But getting back to the statute, because again, the purpose...
But I'm sorry, can you address the Article 78? I just want to be clear. Your position is that, yes, someone like Ortiz, now the estate, could get a refund for being charged double.
Absolutely. I think that...
Okay, but why? How is it incidental when that is the only thing that they want?
Because it is incidental to a determination that the law was violated. She's not seeking...
But that's in every case. I mean, their damages then are always incidental. That doesn't
Well,
seem to really make sense.
No, for example, in Metropolitan Taxi Cab, the court made clear that incidental damages are generally confined to monies that an agency, or in this case Ciox, either collected, and I'm quoting, or withheld from a petitioner and was then obligated to reimburse. In other words, that is the definition of incidental. That's what this court did in the Baku case, in the signature case. It would be different if Ms. Ortiz said...
But it's incidental to a determination of the liability. You concede the liability. I mean, you gave the money back. It doesn't seem that anybody's arguing over that.
No question, Your Honor. And I believe that Article 78 is an appropriate vehicle for that. And the only argument the counsel makes is an argument drawn from CPLR 7806, which was completely rejected by this court in the Gross case, where the Gross case said there is absolutely, quote, no indication the legislature otherwise intended to limit the power of the court to award incidental monetary damages in an Article 78. But again, I just want to be clear.
But we're back to whether or not it's incidental when it is the reason for the lawsuit. It is the only thing that they want. And in this case, you concede the overcharge because you said you paid it.
Your Honor, in Gross itself, the only thing that the city of New York really wanted was the money that the state had improperly held because of an audit that it said was ultra-virus. It didn't really need a declaration that the audit was inappropriate. It wanted the $30 million back, and it was able to...
Well, sure, you always want the money, but you can't get there unless the court renders a particular decision. And there was, of course, the core of the litigation was over this audit.
My only point is that the money, which was clearly the only intent for bringing that claim, was deemed, even though it was the key point of the case, deemed to be incidental. Why? Because it was simply money that flowed from a proper interpretation of the statute. The court says you are only allowed to charge 75 cents under the law. I order you to disgorge. But again, the most important factor is that under the Sheehy test, and I've looked at every single case in the last 50 years that this court has decided, considering an implied private right of action, 24 cases that I've identified, the court has never implied a private right of action in a statute when the condition is met that there is some enforcement mechanism in the statute, even if it's just a public enforcement mechanism. So even if you wanted to disagree with me as to the availability of the Article 78, there's no question, as the Hammer case found involving the cruelty to animals, that was the case with the dog with the long tail. The Metz case involving civil liability for ship disasters, and the McKesson case and the Martin case, the Martin Act. All we're dealing with there was a public enforcement action. The legislature made the judgment. And the one last thing I'll say, if I may, elsewhere in Section 18, at the very end of Section 18, I think it is in F, there is specifically a private right of action in the situation where you ask for records and it's withheld from you. And the court specifically says you can go to a committee, and if after a committee determination turns you down, then you can bring an action. Of course, you're limited just to injunctive relief, but the fact that in Section 18 elsewhere, there's actually a specific private right of action, and again, as Your Honor pointed out, Justice Silva, in Section 19 with respect to the Medicare, they went even further. They did that with nursing home abuse as well.
I think we have it
They didn't
now,
do it here.
Counsel. Yeah, we have it. Thank you.
Thank you, Your Honor.
Thank you. Mr. Pope?
Thank you. May it please the court. John Houston Pope, Epstein Beckman Green, on behalf of the New York and Presbyterian Hospital.
You know, I can't hear you. Pull the microphone up a
Yeah,
little, Mr.
that's
Pope.
not-
Thanks.
is that better?
You're a little taller.
The third prong of the Sheehy test has been well discussed. I want to talk about 1 and 2 for a minute, because I think it's important, and particularly because appellant's counsel makes this argument out, well, we've had this implied right of action floating around for 30 years. I don't think the record bears that out. I don't think if you go through the cases it bears it out. But I want to point out to this court that in the Rocanova case in 1994, it decided that insurance law section 40-D did not have an implied right of action. But it had, for over 15 years before that, entertained the possibility that there might be one, and it floated around in the lower courts. So it's not some sort of bar to this court or some sort of plus for finding an implied right of action that there has been some discussion in the lower courts about the possibility that one exists, or that they may have entertained it as one might exist. We have these citations on page 28 of our brief. I think the court should look at that because it takes away substantial power from appellant's argument, what they think is unique about this case. But I want to talk about the idea of whether or not a private right of action would promote the legislative purpose. Because this court in Burns-Jackson said, let's not have over-deterrence. Let's not have crushing burdens placed through the private right of action on those who are affected by it. That's an important consideration in trying to decide whether or not you're going to apply a private right of action. But this is a case where there would be a crushing burden. And this isn't something that just comes out of the mouths of my hospital. You have an amici brief from the Greater New York Hospital Association and from the Hospital Association of New York. Those entities, which have a broader scope and a broader vision of all the hospitals in this country, point out that there are so many legislative acts out there. There is so much work that is being done to try to be in compliance that this private right of action could be yet another crushing blow to the difficult situation that the hospitals in the state are in, only complicated by the pandemic. Perfection is not
Mr.
possible.
Pope, you know, Mr. Lefkowitz says I could ask the Attorney General to, seek a restitution for me. But to tell you honestly, I wouldn't even personally know where to begin, how to do that. And I know how to start an Article 78, but that's a complicated and fairly sophisticated piece of litigation. What I think everyone can do quite easily is just go down to small claims court and file a claim for the overcharge. And wouldn't that just be the easiest way to protect the consumers? And doesn't it, what's the term, coalesce perfectly with the legislative scheme if the goal is to make sure that they're not overcharged for their medical records?
Well, I'm going to put a pin in whether or not that's the goal of the statute, but I don't believe that that is easy. First off, there's a hotline at the Commissioner of Health's office that entertains these complaints. And the Commissioner of Health, people there call back to the hospital, to the ROI, to whomever, and says, what's going on here? And that's, the refunds happen. I mean, the fact is the refund happened here just by the virtue of learning of the fact that the overcharge occurred. And that's mostly the situation for overcharges, Your Honor, is not that Vicki Ortiz herself sent in a request for her records and they came back. It's because her lawyer sent it in and somehow the paperwork got separated that showed he was the lawyer for her so that the lower price would be applied. Those lawyers are sophisticated individuals who can read an invoice and go through the process of pushing back a little bit and getting the right price charge. The statute entitles them to getting the right price charge and they can push back easily. That's the easiest process, Your Honor. The easiest process is for an interaction to happen between the people requesting and the people providing. And you saw that here. It happened. Immediate refund. So that's the best place. And the administrative process has an additional strength that the small claims court.
I'm sorry, I
and
thought
having
the
been a small
refund,
claims
if I
court-
can interrupt,
Sure.
counsel, I just want to clarify. I may have misunderstood the record. I thought the refund came after they filed the lawsuit.
That's the first we learned that there was an overcharge, Your Honor.
No, I thought he actually complained before then.
No, there's no record of any complaint.
I thought there was a letter sent saying that that was an incorrect amount, but if that's the record, I'll certainly confirm that. But I'm sorry, I may have missed it. Did you respond to Judge Canataro's point, which I thought was, do they have an action that they can go to small claims court to seek the refund? That's a yes or no. Did you answer that? I'm sorry.
There's not an implied right of action, so there wouldn't be a right to go to small claims court. And frankly, small claims court, as much as I would like to think that it is a wonderful process that moves along, I've been in New York City small claims court, and it is a nightmare. You have to show up about 5 times before you get your case heard.
So, counsel, if that's so, why is Article 78 any better?
An Article 78 proceeding, well, I'm not sure that Article 78 is the most superior remedy here. I think the administrative process is, but Article 78 is certainly a process that is available here, particularly when you're talking about mostly mistakes that involve attorney requests, and attorneys are able to maneuver that process well.
Well, then it wouldn't be so crushing, then, it strikes me, which is where you started, that if we recognize this private right of action, it would be crushing to the industry. I'm not so sure, because you've made it quite clear that once you're on notice that there's an error, because there's human error, you'd repay it. And these are sophisticated lawyers who would understand you get repaid. But for then the small number, if that's what it ends up being, the small number of individuals, let's say Ms. Ortiz was doing this on her own. You know, the small number of individuals who try and get their documentation and just get told it's $1.50, maybe they don't know that the max is 75 cents, or maybe not, maybe it's even less because the reasonable cost may be less than 75 cents, right? Why is it such crushing? Why is it so crushing to the industry? I'm a little confused by that.
Well, it becomes crushing, Your Honor, because it becomes the class action litigation that you see in this case, which...
Yeah, but there's not going to be any basis, but counsel, there's no basis for it unless, as she's alleging, there's 86,000 of these errors over a period of time. It does sound like something happened here. I mean, let's assume for one moment that a large percentage of the 86,000 are indeed overcharges that are not supported by the public health law. Obviously, that fell through the cracks. The AG didn't bring that action. The commissioner didn't bring that action. I guess it's fortunate that Ms. Ortiz's counsel brought that action, right? The estate.
Well, Your Honor, the 86,000 figure is not an accurate statement of what's going on here, and it's not in the record. It's in briefs. It's not in the record. I would point out that the reason you don't have whatever remedy there is for whatever number of that 86,000 have a remedy with the Attorney General or the Commissioner is because nobody's complained to them. And I think it's because, Appellate's counsel has no reason to complain to them. That would put them out of work on this particular case. And I don't know who else has complained to them. I will tell you a little story I heard from somebody, which is that this often happens with plaintiffs' counsels who are doing personal injury cases. And they don't realize until the end of it and they've settled the case, that they got overcharged on the amount of the records. And since they pass it through to the client, they don't care. That's the little story I heard from a personal injury.
Well, I'm more interested in I'm more interested in the record than the stories,
Yeah, but
because
I'm
of
saying
course that can obviously happen to an individual who's not sophisticated like a lawyer, who doesn't know, first of all, that there's a cap, desperately needs the documents, and pays it, and for some reason later on does become aware of the fact that they may have very well paid more than they should have paid, and tries on their own to regain that money. I just want to be clear. Your position is that the AG can bring those kinds of actions, the commissioner can bring that kind of action, and that are you too of the school of thought that this would be incidental and available in an Article 78?
I really haven't drilled down on the Article 78, Your Honor. I know that Mr. Leftwitz has, and I've read his brief, and I'm convinced by his arguments. I really haven't drilled down on the Article 78 as well. I think that the administrative apparatus in this is sufficient for the court to find that there is no implied private right of action That's
Okay, so
all-
just to be clear, you cannot represent to us today that should the hospital be sued over an overcharge in an Article 78, that they wouldn't take the position that that is the wrong, that there is no such action in Article 78 for this kind of remedy. You're not able to represent that today. Is that correct?
We haven't looked into it, Your Honor. As I told you, I find Mr. Lefkowitz's arguments to be persuasive, but it's not something that we've taken a position on.
Okay, thank you. Ms. Nam, you have 2 minutes.
Your Honors, if this court concludes there is no private right of action, it doesn't exist for anyone protected by the charge cap. It doesn't exist for patients. It doesn't exist for the parents of patients. It doesn't exist for the guardians of patients, and it doesn't exist for the attorneys of patients that are working on their behalf, advocating for the patient. Given
Counsel, can you address the finance law provision that was referred to by your adversary?
Your Honor, there's no question that the government has vast powers when it chooses to exercise it. The problem is that it is very difficult to get the government to decide that this is the case out of the many, many catastrophic issues facing New York State, that this is the case that they're going to bring on behalf of all consumers, and then refund that, whatever they earn, to those specific consumers who are harmed. That is where the class action platform was specifically designed to do. Here, the issue is who bears the burden of these systematic errors? Is it the individual who has to call up the medical industrial complex and be on the phone for hours? Or is it the provider who can make systemic changes that can provide the relief in a policy way? And I
Counsel, I'm sorry, can you clarify that point that I was asking about the record? And is he correct that they were not aware of the overcharge until after the filing? I thought there was correspondence, so perhaps you can clarify this for me.
Your Honor, the record is that the attorney did notify in writing that this was an overcharge and did file suit. They did not dispute it at the time because they needed the record, frankly. Most people do need their medical records quickly when they're asking for it. So it was
Well, I
after the
just
fact.
wanted to know whether or not the lawyer made a demand for the refund before filing suit. Or is that unclear from the record?
It's unclear as far as I'm concerned from the record. But it shouldn't be up to the provider to decide unilaterally who gets a refund. The statute applies to everybody who's qualified. It isn't for the people who can speak English and can be on the phone for several hours. It isn't for the people who even know that there is a 75-cent cap. I certainly didn't know that before this litigation. It shouldn't be for those people who are like us, who can advocate for themselves. It is for everybody who's in this vulnerable state. Think of when do you ask for medical records? It is a dark time in your life. And for those people to be burdened with the obligation to track down whether they were overcharged, to seek that refund on an individual basis when tens of thousands of those people exist and millions in dollars are being taken by the medical providers, it just cannot be what the legislature intended. Thank you, Your Honor.
Thank you, Ms. Nam.